Well, this is the second discussion video on the Indian polity and governance previous questions of the UPSC Civil Services Examination. We are doing this from 2015 to 24 from Vision IS material. Okay, so in the first lecture we have discussed questions from the Parliament. Okay, now today we are going to see the questions from the emergency provisions. Okay, and then we will move to see the uh, certain some other thing. Okay, so let us jump to the 97 page. Okay, so just a minute, let me write 97. Yes, so this is the 97 page. Okay, 93, not 97. So now here is the 97. So emergency provision. So there have been total number of two questions so far. Okay, last 5 years. Okay, let us see. So the first question that appeared from emergency provision was in 2017 when it was asked that which of the following are not necessarily the consequences of the proclamation of the president rule in a state. Okay, let me bring it a little bit bigger. Okay, I think it is not coming into the frame, so let me keep it here only. So first of all, you should know about what kind of emergency provisions that are there in the Constitution of India. So first you have the Article 352 that talks about the national emergency. Okay, which can so Article 352 it is basically about the national emergency. Okay, who can proclaim national emergency? So it is the President of India who can proclaim the national emergency, on which ground you have either war or external aggression or armed rebellion. Okay, or armed rebellion. Okay, so these are the three things on three grounds on which national emergency can be proclaimed. Okay, national emergency can be proclaimed in any part of of the country or in the entire country. Okay, so there is a no any fixed thing that is there. Okay, with regard to the area. Okay, then comes second thing, that is the president rule in the state. Okay, so it is there in under Article 300, uh, 356. It is the only reason constitution talks about is the failure of the constitutional mechanism in the state. Okay, on which the president can impose the president rule in the state on the recommendation of the governor. Okay, now let us see what are the then you have to remember the consequences, and they are asking not necessarily the consequences of the proclamation of the president rule in a state. You must be remembering that the recently revocation of the president rule in the state of Manipur has been done. Okay, so there was, I think for 2 years there was a president rule in the Manipur. Okay, so dissolution of state legislative assemblies. Okay, then they are asking removal of council of minister in the state, dissolution of local bodies. Okay, dissolution of local bodies. Okay, so let us see one by one. See, whenever there is a precedent rule imposed in the state, then it has nothing to do with the dissolution of the local bodies. Okay, so local bodies will remain as it is. Okay, even if the precedent rule is imposed in the state in a state. Okay, so this is the correct. It is not necessarily the consequence of the proclamation of the percent rule. Okay, so we are just choosing the most 100% accurate statement. Okay, so 3, we know that the 3 is correct, so let us remove that option which does not contain 3. So a has, we are able to eliminate a. Now let us see one by one. Okay, now dissolution of state legislative assembly. Again, see, it is not necessarily that dissolution of state assembly can happen. Okay, so it is also not correct. Okay, so as per the correct in the sense that it cannot be the consequence of the proclamation of president rule in the state. So is the correct for our for us. So you see, B and D is only having A, C is not having A. So we are left only with the B and D. Okay, so 50-50%. Now you see common 1 and 3 are common. Okay, it means that statement number 1 and 3 are 100% correct. which we have already done. Okay, so you see 1 and 3. Now let us see, consider the statement number 2, removal of the council of ministers in the state. So Council of Minister, yes, it is. See, percent rule is happening because there is a failure of the constitutional mechanism in the state, which means that the all the constitutional post, maybe some of the constitutional post are the people who are holding the some of the constitutional post in the state. For example, Council of Ministers that include Chief Minister, State Finance Minister are not performing their duties as in accordance with the provisions of the constitution. That is why governor has to recommend imposition of the president rule in the state. So this is necessarily the consequence of the proclamation of the president rule. So they are asking not necessarily here, so this can't be our answer. So the answer is B. So the correct answer is the B. Okay, so let us see the explanation. When the president rule is imposed in a state, the president dismisses the state. So the president dismisses the state council of ministers headed by chief minister. The state governor, on behalf of president, carries on the state administration with the help of the chief secretary of the state or the advisor appointed by the president. This is the reason why while a proclamation under Article 356 is popularly known as the imposition of president rule in a state. Okay, further, the president either suspends or dissolve. Okay, so it is up to the president to whether he wants to suspend or dissolve the state legislative assembly or not. If he thinks, if he wants to suspend, then he can do. If he does not want, then he can't do. Okay, so that is the thing. Dissolution of state legislative assembly would have mean that all the seats of legislative assembly would have been vacated and fresh election must be held at a later at a at a date. The parliament passes the state legislative bills and the state budget. Okay, so this is important. The parliament passes the state legislative bills and the state budget. The personal rule does not lead to dissolution of local bodies, as I have told you that it has nothing to do with the dissolution of the local bodies. Okay, so that is so 1 and 3 are correct. So what is the source? So you can find this particular information given in the Lakshmikant chapter number 16 in emergency provisions. So in emergency provisions, okay, where it is given center state relation effects of if you see the Lakshmikant chapter number 16, then you will find that they have written effects of uh, in the yes, effects of pertinent rules on the center state relations. Okay, so that particular heading it has covered already everything. Now let us recap once again. So when the president's rule is imposed in a state, the president dismisses the state council of the ministers. Okay, so president rule, see the name itself is saying that the rule of the state elected government has been replaced by the president. That is why it is called the president rule, which means that the president dismisses the state council of the state ministers headed by the chief minister. Okay, the state governor on behalf of the president carries on the state administration with the help of the chief secretary of the state or the advisor appointed by the president. This is the reason why a proclamation under Article 356 is popularly known as the imposition of president rule in a state. Further, the person either suspends or dissolves the state legislative assembly. Dissolution of the state legislative assembly would have mean that all the seats of the legislative assembly would have been vacated and fresh elections must be held at a later date. Okay, the parliament passes the state legislative bills and the state budget. The president rule does not lead to dissolution of local bodies. Hence, correct option is 1 and 3. Now let us see the elimination strategy. You see, under Persian rule, the Persian through governor acts as the executive, and it is not necessary to dismiss the state executive, which is the council of sorry. Hence, it is sorry. Once again, let us see once again. Under Persian rule, what happens that the Persian through governor acts as the executive. Hence, it is necessary. Okay, because president is going to assume all the powers of the executive state executive. That is why it is necessary that you have to dismiss the state executive, which is the council of ministers. Okay, so two option got eliminated. Okay, so two has gone. So if you remove two, then you will get a B. Okay, so that is the correct answer. Okay, so just remember that whenever there is a president rule in the state, then what will happen, that the council of minister headed by the chief minister would be dismissed by the president. Okay, so that is the thing. Now again the next the very next year again a question comes from the president rule only. So let us see this question again. If the President of India exercises his power as provided under Article 356 of the Constitution of a particular state, then the Assembly of a state is automatically dissolved. No, so we recently know that it is up to the president whether he wants to dissolve the state legislative assembly or not. So this is incorrect. So we know so far this is incorrect. Okay. Now the powers of legislature of the state shall be exercisable by the power of legislature of the state shall be exercisable by or under the authority of the parliament. Yes, if it is the state legislative assembly is being dissolved, then the parliament assumes the power to present the budget or bill or making the law legislation on behalf of the state legislature. Okay, so that is correct. Article 19 is suspended in the state in that is no. See, Article 90 is suspended under Article 352 when there is a national emergency. Okay, the president can make laws relating to that state. No, that is not correct. However, he can proclaim the ordinance. Okay, so if there is a no session, but not in the article under Article 356. So B is the correct. Okay, so most suitable answer is the B. Okay, so you have B correct answer. Let us see the explanation. The President acquires the following extraordinary powers when the President rule is imposed in a state. He can take up the function of the state government and powers vested in the governor or any other executive authority in the state. He can declare that the powers of the state legislature are to be exercised by the parliament. Okay, he can declare that the powers of the state legislatures are to be exercised by the parliament. Okay, exercised by the parliament. Okay, he can take all the necessary steps, including the suspension of constitutional provisions relating to any body or authority in the state. The state governor, on behalf of the president, carries on the state administration with the help of the chief secretary of the state or the advisor appointed by the president. Further, the president either suspends or dissolve. Okay, so either he can suspend or dissolve the state legislative assembly. The parliament passes the state legislative bills and the state budget. Article 356 has no effect on any of the fundamental rights. Okay, so that is the correct. So B is the correct answer. Okay, now you have executive total number of questions. You have 10. Okay, so I think it is a big. Let us. So we understand very well about the emergency provisions, particularly the Article 356, which is the state president role in the state. Okay, now let us move back once again and let us see what we have to discuss. So this is here. Now I think amendment. Okay, let us. So we are doing first. We are doing a small part firstly. Okay, a small chapters. Okay, then we will come to the bigger one. So now I think what should we take? What we should take? What kind of thing? Let us talk about the elections. Okay, so let us move to the 129. I think it may be at 130 here. Just a second. Yes, 129. We have two. 124 constitutional bodies. No, I think we have to see the. So this is Constituent Assembly. I think election we for. Let us discuss the amendment of the constitution. Okay, so there have been total number of 6 questions. Okay, 3 questions have come from amendability of the constitution, whereas 2 questions have been from constitution amendments. Okay, so let us see. So the first question is in 2019, amendability of the constitution. With reference to Constitution of India, consider the following statements. So No high court shall have jurisdiction to declare any central law to be constitutionally invalid. Okay. No high court shall have the jurisdiction to declare any central law to be constitutionally invalid. No, this is incorrect. Why? Because the both Supreme Court and High Court are the court of record, and they have the authority to decide whether a law is uh, violating the provisions of the Constitution or not. Okay, so that is incorrect. They can declare any law as to be invalid, constitutionally invalid. So this is incorrect. An amendment to the Constitution of India cannot be called into question by the Supreme Court of India. We know this is incorrect. Okay, it is not immune from the judicial review. So this is incorrect. Both are incorrect. So D is the correct answer. Now let us see the explanation. So 42nd Constitution Amendment Act 1976 inserted new Article 200 228A. After Article 228 of the Constitution, special provisions as to the disposal of questions relating to constitutional validity of state laws. No high court shall have jurisdiction to declare any central law to be constitutionally invalid. However, the 42nd Amendment Act 1977 restored the original position. Hence, statement 1 is not correct. Okay. In the case 1 of the Bharti case 1973 case, Supreme Court laid down on new doctrine of basic structure, basic features of the Constitution. It ruled that constituent power of Parliament under Article 368 can amend the Constitution under article, but such amendment should not enable it to alter the basic structure of the Constitution. Anything that ultraviolates the Constitution is cut down by the higher judiciary, including the Constitutional Amendment. Hence, statement 2 is not correct. Okay. Now, source is again the Lakshmi Kant, Indian polity. Now, second question. Consider the following statement. The 44th Amendment to the Constitution of India introduced an article placing the election of Prime Minister beyond judicial review. Beyond judicial review, yes, correct. Okay, so placing no, it was introduced by the 42nd, not the 44. Okay, during Indira Gandhi, it was Madam Indira Gandhi who has introduced this kind of provision under, I think, 42nd, if I'm not wrong, because 44 happened in 1978 when Indira Gandhi was not in the power. So I think this is incorrect. The Supreme Court of India struck down 99th Amendment Act of Amendment to the Constitution as being violative of the independence of justice. Yes, this is totally correct. So B is the correct answer. Explanation: the Parliament passed the 39th Amendment to the Constitution, which removed the authority of the Supreme Court to adjudicate petitions regarding elections of the President, Vice President, Prime Minister, and a Speaker of the Lok Sabha. Instead, a body constituted by Parliament would be vested with the power to resolve such elections disputes. Okay, amendments were also made to representatives, so all these things you can see. So we'll stop here. Thank you.